Barbara?
Good evening, everyone. I think we'll get started. We're trying to, get started on time every week. So thank you so much for coming out. We've been so pleased to have a real mix of our students and staff and faculty and our local community members. We just can't tell you how much we appreciate people coming out for these conversations. So tonight is our second in our series, and we're very honored and pleased tonight to have the current president of University of Vermont, Tom Sullivan, and our former president of Bennington College, Elizabeth Coleman, to join us in a conversation about the Constitution and its relationship to our democracy. Something that I know we've been hearing about the 14th Amendment. We've heard a lot about the Second and First Amendments in the last couple of years. But of course, there's a lot more in our Constitution that I think a lot of the time we haven't really been paying attention to or read about, just a lot of confusion. So we thought tonight was a way to begin to address this. We do have copies of the Constitution for everyone to take home with them after this tonight, and so we thought that might be something that people would appreciate. So they're over there, we'll let you know. Okay, I'm going to turn it over now to our State Senator Brian Campion and our Director of Public Policy Programs at the Center for the Advancement of Public Action, who will introduce our guests, and we'll get started.
Thank you, Susan, and welcome, everyone. A special welcome to the students who are required to be here. Understanding the Constitution is essential for a fully informed, engaged, and active participant in this democracy. No more so than right now. Tonight, with the help of our two guests, we hope you will better understand this remarkable document so you can recognize when it is correctly referenced and, more importantly, when it is misrepresented and twisted for political or social purposes that fly directly in the face of the document some pretend to understand. Elizabeth Coleman served as the 9th president of Bennington College from 1987 until 2013. Coleman graduated with honors from the University of Chicago, completed her master's degree in English and American Literature at Cornell University, and received her PhD with distinction at Columbia. In addition to a career in teaching, Coleman has been a consultant to the Annenberg Corporation on a public broadcasting project and a visiting fellow at the Neurosciences Institute. She served on the board of directors of the Neurosciences Institute, the Committee for Economic Development, and the Council of Advisors for the European College of Liberal Arts. In February of 2009, she delivered the closing speech at the 25th anniversary TED Conference in Long Beach, California, entitled Engage. Of Liz's lengthy list of achievements during her time as president, many, without a doubt, consider her greatest to be the building in which we are seated and the idea on which this building was founded. Tom Sullivan became the 26th president of the University of Vermont in July 2012. Prior to becoming president, he served as senior vice president for academic affairs and provost at the University of Minnesota, and served as the 8th dean of the University of Minnesota Law School. On several occasions, he has been a consultant to the United States Senate Judiciary Committee on judicial nominations to the Supreme Court and to the United States Senate Commerce Committee on mergers. In 2015, he received the Robert J. Kutak Award from the American Bar Association for his contributions to the legal academy, the judiciary, and the bar. President Sullivan graduated magna cum laude from the law school at Indiana University, where he served as the editor of the Indiana Law Review, After law school, he clerked for a federal judge in Miami, Florida, and thereafter was a trial attorney in the U.S. Department of Justice for the Attorney General's Honors Program. Similar to those to last week when we had Governor Howard Dean here, the three of us will start with a conversation, and then soon we'll open it up to all of you for questions. So we will have a conversation with the audience. But before we begin, please join me in welcoming Elizabeth Coleman and Tom Sullivan. Everyone hear me okay? How's that? There we go. So I've asked President Sullivan to start the conversation by talking a little bit about the history of the Constitution and saying a few words about it. President Sullivan.
Thank you, Brian. Well, it's a delight to be here with you back on the campus. Thank you for the invitation. I want to just begin my introductory remarks in three parts. First, I want to share what I think is the kind of structure of the Constitution, or architecture, if you will. Second, hit very quickly what I think is the core thrust or theme of the Constitution throughout its structure. And third, just to open the questions to identify 5 or 6 core themes or values expressed throughout the Constitution. So first, with regard to the structure. As you may remember, the Constitution was adopted in 1789. The first Congress was in 1790, and the Bill of Rights, which I'll talk about in a minute, 1791. So 1789, its Constitution is basically in 3 parts. Article 1 is the Congress and its powers or its delegation. Article 2 is the presidency or the executive branch, and Article 3 is the judiciary. When you look at the structure of Article 1, Congress, 2, the presidency, and the judiciary, you can see that the design or the architecture is really there about checks and balances and separation of powers. One to play a role in certain regard, and the other to defer or to be primary over that subject matter. Now, if you look at those words, separation of power or check or balance, in fact, have a tension between them. Not to frame that tension, but it's clearly there. If you're supposed to be separate and distinct from the other branch, it's hard to be a check and balance on the other branch. So you can see how the interaction may play out there. Then in 1791, the Bill of Rights, the first 10 amendments. And the reason later, in this case 2 years later, is because there was great debate and convention to draft the Constitution, and they couldn't get consensus, quite frankly, on the subject matter that was in the Bill of Rights. They got the Congress started in 1790, and they began to address a Bill of Rights, which we now know are the first 10 amendments. The most important, many people believe, is the first one, and that, of course, has the speech and the press and religious freedom and the right of assembly. And I think history records that it probably is the overriding or overarching value because they put it in the first one rather than down the line. My second point I want to make as we begin our conversation is wherever you look in the Constitution, the overriding sentiment, starting with its preamble, really is about promoting the public good, the welfare of the people. That underlying notion is throughout the Constitution and is very important when you go to interpret it to say, well, what did they really mean? Well, it's about promoting the public good. But of course, you know, the debate is about what is the public good in a particular argument. Finally, in my introductory remarks, I just want to mention 5 or 6 areas that I think are the most important principles that animate the Constitution. And there are many more, but the ones that we hear about and should pay close attention to. First of all, the Constitution, and particularly the Bill of Rights, are really about limited government. It's about what the government, in this case, the federal government, but then through the 14th Amendment, it all applies to the state governments. It's about limiting the government's power, and that, of course, comes from the history of fleeing from Britain and getting away from the King, King George, and so forth. So that's the underlying theme. The sovereignty and the individual autonomy against one's government that can be oppressive. Very important principle. And we find this liberty principle, freedom of liberty, throughout the entire Constitution. And it starts right in the preamble and then directly right through the first 10 amendments or articles of the Bill of Rights. Liberty. And liberty here means liberty to be free from government arbitrary actions or censorships. The autonomy of the individual against one's government. That's why we had a revolution against George. The second is the due process clause, which I happen to think is the most important part of the entire Constitution. The Fifth Amendment in the original Constitution and the Bill of Rights, and now more recently the 14th Amendment. And what the due process clause says is the government cannot interfere. Again, going back to this self-liberty thing. The government cannot interfere with your life and your property. And what that means is only with a process that's due can they interfere with that kind of liberty. That pervades everything and every interpretation of the Constitution. The due process rights that you have against your arbitrary capricious government. Checks and balances, separation of powers I mentioned. Judicial review, of course, became very important in Marbury versus Madison, one of the very first opinions from the Supreme Court, penned by Justice Marshall. Up until that time, it wasn't clear how strong or how dominant or what kind of a check ultimately the judiciary could have on the other two branches. But in Marbury versus Madison, Justice Marshall was very clear that the court has judicial review over all government, as long as there's a case or controversy. In other words, a real controversy, not just a hypothetical problem. And this was never directly written in the Constitution, but it certainly runs through the Federalist Papers, which is, for you political scientists here, the most important political science document ever written or read. The Federalist Papers, telling us what the interpretation of the Constitution is. And finally, I would just mention, after judicial review, my last principle that I think is critically important, is federalism. Now, federalism is this concept about where is the allocation of authority power between the federal government and the state. Oh, I said that the Constitution was about a limited federal government. There are very specific powers in Article 1, 2, and 3, which tell us exactly what powers are given to the federal government. And then the debate or argument goes, and then are the rest given over to the states? And so you have this tension between who's on base, who has control, the federal government or the state government, and that's called our federalism document. So I think for kind of structure, we can.
Is it picking up? Good. Thank you, Jim. Nice to learn about this document, finally. I'm going to go at things a little differently, just for contrast purposes and others. I want to start with a quotation from Alexander Hamilton from those Federalist Papers. Hamilton had the wit not only to provide us with material for one of the great musical performances of all time, but he also deserved it. This is Hamilton from Federalist Number 1. It seems to have been reserved to the people of this country by their conduct, let me say it again, seems to have been reserved to the people of this country by their conduct and example to decide the important question, whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force. These words, I suspect, are impressive under any circumstances, but certainly in the country we live in today, they have a very special resonance. And they would soon have a lot to do with your decision to have a series of conversations about the very essence and issue of the fate of democracy in the United States of America. One of the things that Hamilton is emphasizing, of course, is who is it reserved to make this extraordinary decision? The people of this country. You are, most of you, the people of this country. And so one of the things I'd like to emphasize in the few minutes I'm going to take here is the extent to which this document makes that point. In a sense, the government is you. And the extent to which it is not is the extent to which you delegate to specific bodies certain powers. But the source and sovereignty on which this government is based is you. And that's made extremely clear by the opening of the Constitution, which begins, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution, the United States of America." My first question to you would be, why does it matter that the opening word is "we"? And to imagine what it would mean if it was any other word, and imagine what it means that it is that word. And what does that mean for everyone in this room who is a citizen of this nation or who would hope to become one? I can't emphasize enough the time you might want to spend on why it's we. It's not I, it's not they, it's not us, it's not the people, it is we. And it is taking the issue of the source of authority, the source of sovereignty, the source of all legitimacy is located in you. That raises a very important question for me about this conversation tonight, which is what does it mean if you sit and wait for us to tell you about the Constitution? We can do what we try to do here. We can point you in different directions. We can underscore certain things. We can suggest that there are good wisdom to this. Maybe not. But what we cannot do is to relieve you of the responsibility of engaging in this text passionately, deeply, on way. One of the things that my own experience engaging in this text, I found cases that requires two things. One is to read. It is a very demanding text. And what I mean by read is watch people like Jim or lawyers actually about this document. One of the things they will over and again is the other section text, which has similar cadences and speech, and words where they're repeated, where they're changed, what's going on, as they make sense and interpret as precisely or clearly what this document is actually saying. So what you want is magnificent. So those of us who are church of this, think it's document to spend time on. The other things that no less important is you can't get it along. Really need to listen to people where you're engaging, trying to say, hey, that allows you to kind of find ways to see this They really did. And a lot of school is going on now, except about things like we have no equipment, but how many people in screening have a clue about what a document that they're claiming in class that's something we really need to learn about. I just want to point out a couple other things before we turn over to you guys. Certain things that I find personally, and that I suspect others as well, that are very remarkable about this document. So here these guys sat for several months. It was very hot. They closed the doors, so it was really hot. And they worked day and night to prepare this brilliant piece of work, right? One of the interesting things about this thing that they prepared at such length and with such care and with such endless debate is that it closes with two striking articles. One is how you change it. So one of the ultimate final moments in this document is after they told us this incredible way to govern and how you do it, powers, and just where you draw lines and you don't, etc. They end by talking about, and this is how it changes. This is an article in the document. This is how you ratify it. And its final article is how, not how you ratify it, how you change it. The final is how you ratify it. So that until the people of these United States, 9 of the states, ratify this document, it is not worth the paper it's written on. So one of the things that's just wonderful to think about is a document where, with all of its talent, its thoughtfulness, and it has its weak spots for sure, certainly its treatment of slavery leaves a lot to be desired. The extent to which the spirit of inquiry, of engagement, of continual and ongoing engagement is absolutely essential to the vitality of this document. So my advice to you tonight is listen to all the genius that we have to present you with, and the insights and all the rest, and then go home and read it yourself.
Yeah, please. Just a comment if I could. Liz made the point about the reading. Is that working? And I don't think she was implying that this is a long, complicated, or sophisticated document. It is not. It is the oldest written constitution in the world under choice. 4,400 words. But each word, as Liz was saying, is so rich with intent and purpose and context that you do have to refer back to Article 1, 3, and 2 as they compete with each other for power and dominance. And with Liz's permission, I'd like to read that preamble again. Because these are such powerful words, and they give complete meaning to the document. We the people, she said.
No, I didn't.
I know you weren't. We the people of the United States, in order to form a more perfect union, establishing justice, ensuring domestic tranquility, providing for the common defense, promoting the general welfare, and securing the blessings of liberty. To ourselves, remember that definition of liberty, against my government, and for our prosperity. Very powerful words. We the people. This is our government. It's our Constitution. Each one of those articles tell us the responsibility of the Congress, the President, and the judiciary to be ultimately interpreted by the courts with a lot of history and context behind it.
Let me start by asking you, Tom, when we were on the phone getting ready for this, I think we were talking about how Jefferson referred to this country as a democratic republic. And I'm wondering if you might say just a few words about, is this a democracy? Is it fair to say that the United States is a democracy, or is it a republic? Or would you, the name of this series is Democracy Siege. We have a course going on that's here, a course called Activating Democracy. Onto that.
Yes, and my response can be brief. The word democracy never appears in this Constitution. Second, when Liz's reference, when the founders were coming out of the Constitutional Convention ready to vote on the document, a woman turned to Benjamin Franklin. Is it a republic or a monarchy that we have now? And Benjamin Franklin responded, and I think very apt for today's conversation, our society's conversation. His response was, it is a republic, not a monarchy, and it's not a democracy in the sense of direct democracy.
You mean about whether it's a republic or a democracy? Not. I think that I'd like to try to figure out what the underlying issue is. I suspect one of the things that you're getting at is the complexity of what it means to exercise power when the sovereignty is in the people, and that is a great challenge. And the language of republic or democracy is the language of how one tries to do that, how one negotiates the enormous issue of if the sovereignty of government comes from the people, how is that exercised? Just to make another observation about this issue of sovereignty, this country has just gone through a revolution. What was the revolution about? It was about throwing out the government, right? This was a British country, had government, had all kinds of stuff, and they threw it out. Now what? Think about it. Where do you get the authority to do anything? You've just thrown out all the sources of presumably legitimate authority. Who's to say now? On what basis does anyone claim anything that has to do with the power of governing others? So one of the interesting ways of thinking about this is to appreciate the extent to which, when you've given up all sources of traditional, conventional governing power and authority, one place you can go for authority is the people.
And I would just add that, of course, after we threw off the king and won the war, we first had the Articles of Confederation, which were very imperfect and quite horrible in many respects. And so it was the reaction to the failure of the Articles of Confederation that brought them together to form a more perfect union through this document. So there was that iteration from the king to this document. It was the experiment with the Articles of Confederation. And they were responding to its failures. And that's how you see many of these, the structure as well as the terms, trying to make it a more perfect union from the failures of the Articles of Confederation and, of course, from the king's regime and the dominance of it.
So before I start calling on people randomly, I do want to jump right in and think about politics right now in the United States, and I want to talk about the Second Amendment. Second Amendment is talked about a lot, certainly in the state of Vermont, as well as in the country. And I'm wondering, a lot of people who are, well, it's mixed. There are people out there that believe that the Second Amendment does some things around firearm regulation, around holding and keeping a firearm. There are others that believe that there's flexibility in the Second Amendment around that issue. And I'm wondering, Liz, if you might say something about that. If you have.
You mean about the Second Amendment?
Well, how would you interpret the Second Amendment? If you're somebody that actually, you're a member, is there flexibility? Let me start with that.
Let's start by reading it, okay?
You're running for office, maybe you want to answer.
There's no way I'm answering that.
Puts it on
But
us.
let me say something else. You know, in the State House, as well as state houses across the country, in our own United States Congress, the Second Amendment is held up as something that folks will say, I am allowed to have this weapon because of the Second Amendment. And,
Okay, I'm ready to
you're ready.
Stop
I
talking.
gave her a little time so she could familiarize herself.
Thank you. All right, enough. So I'm reading it, right? I mean, that's my point tonight. A well-regulated militia, comma, necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. So this is how I would go with this. I would say, I don't know of any other of the Bill of Rights which has a conditional phrase at the beginning.
True.
This does, and it's rather precise. A well-regulated militia necessary to the security of a free state. Well, we've changed the nature of that well-regulated militia. It is now the National Guard. And I would argue, given the change in the circumstances that legitimize this, we no longer need it. You can have a perfectly well-regulated militia necessary to the security of a free state without the right of the people to keep and bear arms. So I myself, since I'm unbiased, totally neutral, only care about the truth and justice, I would say clear. This is an historical, this one, the only one, is based on an historical issue. The historical issue has dramatically changed, hence, what follows from that issue should dramatically change. Done.
Liz's emphasis on the comma is key. I agree with everything she said, by the way.
You didn't arrange this beforehand.
No, we didn't talk about Second Amendment. I'm not sure we're supposed to in Vermont. But this is controversial now because of the Heller case a number of years ago decided, majority opinion was written by Justice Scalia. Now let me talk about two terms that are thrown about frequently in constitutional history or interpretation, originalism or textualism, which they have various definitions, but originalists with Justice Scalia and company would say you look at the plain meaning of the words, the text itself, just like Liz said earlier, as a literature critique. And if it's plain and clear, then that's the way it is. If it's not quite that clear, then you go back to context, Liz's point. So let's read that again. A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of people to keep and bear arms shall not be infringed. What was the context? The context was local people coming out of and during the Revolutionary War had guns and muskets in their house and around them because they were part of the local militia, today would be our National Guard or Reserves, because they were fighting the British, who were all around the colonies. In order to maintain that militia, comma, one can bear arms, period. It was contextual, that plain language. We don't have that circumstance today. That's Liz's point. We have professional military and National Guard and reserves and so forth. Now, Justice Scalia was proudly proclaimed as an originalist. When the Heller case came up, I thought, well, this should be easy. That language could not be more plain, particularly with the comma there and the clause preceding the verb and the noun. But that's not the way he wrote it. So be careful when you hear the words, I'm originalist or I'm a textualist, because I read it very closely.
But Tom, what if the Vermont Constitution doesn't have that condition? You know, you were talking about the back and forth a little bit between the state and the federal government. What if the Vermont Constitution doesn't have that?
Well,
Who sort of wins that?
To go back to Marshall, Justice Marshall Judicial Review, and the vernacular is, it's the United States Supreme Court that tells us what the law is. So whatever the court says it is the law, period, okay? So, and we know from the United States Constitution, when you have a state provision in conflict with a federal provision, whether it's statute or the Constitution, the federal always will be supreme. Okay? So to answer your question, when you have a conflict between the Vermont Constitution and the federal Constitution, the federal will dominate. Now, having said that, what the court said in Heller was far more narrow than what the popular press or popular conversation would suggest. All Heller said was, you have a right to have that gun in your house, in your home, period. The Supreme Court has not gone beyond that. A lot of lower courts have interpreted much more broadly, but that's not what Heller said, even in Scalia's sweep of the language. So I think a good argument could be made if you want to restrict, you have to have some fidelity to the actual language of the court in your home, even if we would argue that the context is wrong. So all of these expansions on these fancy military weapons clearly don't come within the Heller definition, in my view. Now, what the Supreme Court might say today, given its makeup, is debatable. But I think the press and commentary around it has expanded the application of Heller well beyond what it ever said.
Bruce, you want to see? Yeah, I want to disagree with you on not on the Second Amendment. Your statement that whenever a state constitution or act is in conflict with the federal law, that's not quite true. It's true up to a point. Let me use the Fourth Amendment as an example. I'm a New York State attorney. Would you remind everyone of the Fourth Amendment? Yeah, I will. The Fourth Amendment, in general, we say, protects people against unreasonable persecution. Okay. The federal government had a right, the Supreme Court in the United States had a way of defining it. You might have a reasonable expectation of privacy. I had a case in New York, and the New York State Court of Appeals ruled that the search of a person's abode underneath a bush in Central Park was, in fact, a place not where the federal court would allow it. The federal court would have allowed that search. Nobody had a reasonable expectation of privacy under a bush in Central Park. The federal court has said that clearly. So the federal court sets a floor, but not a ceiling to rights. So in New York, if you happen to live in Central Park, the New York State Constitution trumps the federal Constitution, granting you more protection against police invasion of your property. So the relationship between state constitutions and federal constitutions are entirely dependent upon whether we're talking about a ceiling or a floor. And with regard to the Second Amendment, I have no clue, although I think that I recall the Vermont Constitution is pretty expansive in terms of its rights. My position is that the right to possess a gun, firearm, in Vermont is substantially greater than it would be in my home state of New York. Because my New York Constitution basically parallels the federal, whereas Vermont Constitution is greater. Vermont has more rights to carry guns. And so the relation, I would agree with you in general with the supremacy clause.
Yes.
Yes. So the supremacy clause doesn't apply when we're talking about
I agree with that, but my context, my point was, the states cannot have a more restricted than the federal government, because then you have a direct conflict of interest with power. So let me give you an example there in Colorado. So, I guess we go back to the beginning. If the state of Vermont restricted the right to gun more than the politics at the end, that would be in conflict and not always fall to the federal. So I'm talking about when the state has a restriction greater than what the federal is.
Questions, or Liz, you want to say something? I have a question for you. Is anybody in this room not a United States citizen? Yeah. Okay. What I'm curious about is how this reads to you, how you see this conversation. As if, I mean, Americans have a tendency, we're talking about our Constitution, to act as if the rest of the world should pass out and delight and pleasure in what we have. And certainly in this room, there's a sense of, a dangerous sense, I suppose, at times of complacency, but I'm just interested in what any of you may have to say or think.
Or do you want to take that question? Do you want to say something about that?
I'll bring you up the mic. Maybe say a little bit where you're from.
My name is Hur Arifi, and I'm from Afghanistan. So I'm from a country that our constitution is written by patron clients and sovereign states, and I'm sure that a lot of people have no clue of what about the constitution in Afghanistan. So something which is very unclear to me about the United States constitution is that it might be in fact true that I cannot find any word of democracy and democratic in the U.S. Constitution. So I'm just wondering about the role of democracy under a federal system, and if you think that, and then something also intriguing is there is also not any word mentioned about the Bill of Rights in the United States Constitution. So I'm just wondering, like, what are things that as U.S. or non-U.S. citizens we do not know about U.S. constitutions?
You're correct, and I mentioned earlier the word democracy was not applied, and was not. Can't find it in the Constitution. But nevertheless, the political philosophy of the time during that was all about democracy. So it was the underlying theory that informed documents, but they chose not, I think, to use the term democracy directly because of the way they structured the article. Article 1, Congress. So people, when they think about democracy, they direct democracy. So if you look at the law, everybody wants to vote. That is a form of government, we should recognize. That was not what they were intended in the Constitution. And indirect democracy, you go to Article 1, you elect representatives. Congress is the Senate. Article 2, you elect the president. So that's, and Article 3 is the judiciary, where federal judges are not elected other than by the Senate, by a majority.
There's where you have the indirect democracy that came out of the philosophical discussion informing the document itself. Now, just one point about the judiciary. So there's been a huge debate in the history about unelected judges. There's a brand new book out, again, assaulting judges, because they're not elected, and we live in a democracy. Well, actually, the contrary argument is that Article 3 wanted its judges to be independent from the political fray. Now, we can argue whether they are or aren't, but that was the theory. But it is the president who nominates, and it's the Senate who confirms, gives its advice and consent by a majority, as we've just recently seen. So you do have a democratic principle and element at work, even in Article 3. Okay, so that's where the influence of democracy comes, but the structure of the Constitution makes it much more a constitutional republic than what you might be thinking as a direct democracy.
Just two observations. This is not a document about political theory. Okay, so I think what it is an exercise in governing and in designing government. It would seem to be rather strange if it were to go on about whether or not it was a republic or a democracy. It is, as I see it, at least, the attempt to design and craft a government where the preamble seems to me to suggest as radical a principle of some other source of the power of governing than the governor. And the extent to which that other source is we, you have your work cut out for you. And another observation I'd like to make, when you ask what's in it, there's a lot that isn't, as I think at the end you alluded to. One of the most fascinating parts of the story of the Constitution, for me at least, is the unfolding of the amendments. And there are quite a few of them, and they are one way of looking at the evolution of what one calls it, the evolution of governing the United States, the evolution of the extent to which is the people that is moving towards the light or away from it. And there are some of us who think in those extravagant terms about the issues at stake. In any event, that is a very important part of this, and that's one of the reasons I mentioned that in this document that people had killed themselves to make perfect, really, really wanted it to be perfect. The next to last article is how you change it, and indeed it has been. So that's another very important part. But there were some other people who wanted to. Well, who was in the military? But it really is an issue. You're talking about the military as if it was an institution, certain characteristics, certain leadership, certain clear centers of power. But indeed, actually, one of the reasons they had to abandon the Articles of Confederation was because they couldn't get the states to ante up what they owed. And so the guys who had risked their lives, many of them had lost them, and their families were not getting paid. So this famous military who was waiting to get some clothes on, some shoes, so the idea of there being an institution with a history of power and authority over the citizens is probably not quite the picture that we had at that time. There are other answers to that question, of course. Remember, this was a revolution. This was a battle to take away the power of others over the people in some sense. That was what it was about. So it's what it means then to exercise that power is a whole other.
Yeah, the role model, if you will, was the presence of the British military. And that would be the last model that we would want to adopt into the Constitution. And the Articles of Confederation and the Revolutionary War itself demonstrated that, quite frankly, we won that war in a ragtime, kind of rough and tumble local folks with those muskets in their house. So they didn't have that kind of mentality, I think, about an organized, effective, efficient military. No, those were the folks they just defeated. And they didn't have it already at home. So that would not have become the imprimatur for them to look for. And again, Liz's point, we, the people, not the military or a monarchy.
Well, the people were the military. It's a citizen of the sure. Oh, of course.
Liz had asked the question about students who are not citizens of the United States, or to weigh in a little bit, give their thoughts. Any other student here that might want to say something about their impressions of this conversation around the U.S. Constitution? Okay. Wendy, did you have a question? No? Okay. All right. I thought I saw a hand up. Questions? Judith.
Yes. First, let me be clear for historical accuracy. When the framers said "we the people," they weren't talking about women, and they were not talking about people of color. They were not talking about people who had been enslaved or were enslaved. They're not in this Constitution. 1920, the right to vote for women, and of course the Civil War and its aftermath. So we need to be clear that "we the people" isn't quite as lofty a phrase as today we would want. United citizens. If you follow the linear history and trend line of the First Amendment speech, which really started about the 1960s, 65-ish to the present, you will see that the Supreme Court, whether not partisan and not political, whether it's Democrat or Republican nominee, they have been in almost an absolutist march in interpreting the First Amendment. Congress shall make, the government will not censor. That's the language. And so when we got to United Citizens, two things were going on. The court had really expanded the original interpretation of the speech clause as absolute, almost always applies unless you fall into those four exceptions of defamation, obscenity, speech part of criminal conduct, or a clear and present danger threat. If it doesn't fall into one of those four, today our Supreme Court, and 20 and 30 and 40 years ago, would have said absolutely protected speech. Okay. The linear outcome of that is, if you characterize a business or a corporation as a person, and they've already said a person has these First Amendment rights, it follows, doesn't it? Because basically what United Citizens said is, money is speech. Put your money where your mouth is, speech. See the linear logic? The problem is, I think the court was completely wrong in defining a corporation as a person. Corporations are artificial entities created by state charters. And from there, the court leaps that they're a person like the rest of us. No, I'm sorry. So that's, I think, the deep fallacy with United Citizens.
Okay. So I'm going to disagree with my colleague here. we the people means the people. One of the things that we tend to do, I think, is we want to be very careful. God forbid we should be too idealistic or not capable of seeing some of the more grim dimensions of situations. But one of the dangers of that is to lose a very important part of this document, and I would argue also even more of the Declaration of Independence, which is what I would call aspirational language. Principles, yearnings, desires. Where are we going? What is it that drives this? What is it that gives it the kind of legitimacy that can, yes, stir the hearts and minds of human beings to acts and dimensions of their participation in life that they might not otherwise be capable of? So, yes, it is we the people. Now, when it comes to citizenship, whole other story. And in fact, interestingly, to my knowledge, the Constitution never uses the word citizen, and one has to some extent conjure up what it means by implication. But what has happened in the history of this document and in the history of this country is that we, the people, has increasingly become, in fact, broader and broader and broader definition of who's included, and what is it that drives that process? What is it that is the kind of lodestar, the kind of sense of when this country is in sync with itself and when it is not? And one of the things I would suggest, and one of the ways it does that, is by these stunning statements of yearning, of aspiration, and hope. And they are made unqualified as they should be. So the Declaration of Independence is even more startling in the rights and privileges that it gives to human beings as such. So just a matter of difference. Obviously, these are issues to discuss and to iron out and to think about. And one of the things I hope you leave with today is knowing none of these issues are issues where there are one-liners, even in mine. That's a joke. But they're issues that cry out for, that want, that love the back and forth, the give and take, the struggle. They matter, these questions, and they are not to be resolved by one voice.
But Liz, I mean, the question was about Citizens United, the case itself. Do you want to say something else about the decision itself?
No, I mean, I think enough has been said. We all know it's a terrible decision. So much for that, as far as I'm concerned. But it seems to me to go back to the earlier question about how this document works. If you look at the amendments and the unfolding of them, one of the things you see is you see moments of horrific decisions. One of the worst, the fugitive slave ruling, which was 7-2, in which it made the Constitution look like enlightened on the issue of slavery, because it claimed that slaves were not people. In other words, African Americans were not people, they were property. And people were obligated, under any circumstances which are imaginable, to return that property to the people who owned it. Okay, that was an amendment to the Constitution of the United States, and the ruling was 7-2. To me, and you watch that work itself through, and you watch the issue of who votes working itself through as the Constitution unfolds. We are going to watch the issue of money working itself through. And one of the striking things to me about the Constitution is it never addresses the danger of money. Not in the sense of thievery or arrest, but it didn't see. The one thing it didn't see was the corruption of money as a source of power. It just is nowhere to be found, a sense of that. I'm not talking about thievery. Well, but that's more about thievery than it is, maybe not. All right. So go after it, Susan. Let's get in the courts here. It's clearly an enormous issue in the United States of America. And one encouraging thing I would suggest to you is that if you watch the unfolding of this stuff over time, what tends to happen is we finally get it closer and closer to where it needs to be. And one of the fascinating questions is, where is that direction? Where does it come from? And I would argue it comes in part from these remarkable aspirational statements that define this country. We the people being one of the most astounding.
I agree with Liz's emphasis on aspirational. But let me read you the actual text of the 14th Amendment, and I'll join this to a conversation that the country started this week, when our president mentioned that certain people should be disenfranchised from their citizenship. Section 1 of the 14th Amendment, you'll remember the 14th Amendment came about after the Civil War in 1868. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Period. That's pretty clear, isn't it? Even if we're originalists or textualists. Maybe especially. Now, one of the arguments that was proffered is, you know, they say that you have to have an amendment to change that. Well, the amendment process that Liz has talked about takes 2/3 of both chambers or 2/3 of all of our legislatures. That's not going to happen. We have never changed in that way very often. So let's not think that's a resolution. But let me turn to the last clause of the 14th Amendment, which is another argument made in an op-ed piece in yesterday's Wall Street Journal, that you don't have to have a constitutional amendment to change the language I just read, because the 14th Amendment, the last sentence, gives the Congress the power to change that. No. Let me read you Section 5 of the 14th Amendment. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. To enforce, not to wipe it out. So again, on the face of that one sentence in 2 words, to enforce, to enhance, to make it better, more powerful, not to denigrate or take it away. So I think the answer is you revert back to the original plain meaning, the language which says, are citizens born in this country, and the only way you can change that is through a constitutional amendment which will take 2/3 of both chambers plus 2/3 of the states. That is the law today.
I did see some hands up. You had a question, please. Anyone? So basically, are you asking the question, does the U.S. Constitution protect those folks in the territories, in part?
The territories of the United States, they have those rights. And we go back then to the 5th Amendment and to the 14th Amendment, which has exactly the same sentence, which says they are entitled to due process, life, liberty, and property. And the government, in other words, can't mess with you unless there's a certain modicum or degree of process that's due you before they can interfere with your rights. That's what the due process clause says.
Okay. I see a hand up.
be political?
One.
But I just read you, I think, the answer. He has no constitutional authority to do what he said. Well, so as a practical matter, if he tried to, what I believe will probably happen, if he enters an executive order in contradiction of that section, the ACLU or some public entity, or perhaps a lawyer representing a person who falls into that category, parents who are not American citizens, but the baby was born here. That clause is clear. You go into a court, federal court, and you get a federal judge to enter an injunction against the enforcement of that executive order. And then you have the constitutional issue, and we're right back to defining that sentence.
The Constitution is not going to protect you unless you protect the Constitution. And that's one of the reasons I started by saying why you have to read it. As long as the people in this room need people in front of you telling you about this document as your only source, it is unlikely that Trump will have a lot of trouble, or Trump-like people will have a great deal of trouble in deciding what it is and what it isn't. And I'm not saying this, I mean, you'd expect it from me, you know, right? Teacher, college president, wants people to, this is deadly serious. As long as the people in this room do not know that document in some meaningful sense to them, make it part of who you are in some way, what the Constitution is becomes another question of power, of course, like everything else. And this document is about power. But it comes alive to some extent when we live it. And that's a very, one has to ask, this is the only way I know how to ask any important ethical question of myself, what would happen if what I do, everybody does? What would it mean? And indeed, on this question, it seems to me pretty clear what it would mean. So, and I have another question I'd like to leave with you that has something to do with this. This is an astonishing document. It really is. And all of us can get help. It's not easy. Its language is anything but stirring. At some moments it is. But it is remarkable in terms of what it did. It made a nation. And it has a kind of excitement about it, an exhilaration, particularly when you read the amendments as they unfolded. But the question I ask myself, so I'm going to ask you, is, does it matter that our history as a nation, this document is so essential in that history? Does it matter in terms of the now, as you're asking, what is going on in this country now? Does that history matter in terms of what we can do about it and how we can view our future as well, of course, as the present that we have this history?
Yeah, so I'm just curious. We're sitting here, you both have been college presidents. Liz, when you were 25, did you know this document? Inside and out in a way that you want these folks to know?
Of course.
No, I want, because this, at what point in your life did you say, gee, I really know this? What were the things in your life that made you really realize that this is something you need to understand and understood the essential pieces that is part of being active?
Yeah, well, one is when you asked me to come and sit in front of a room of people and say, what do what matters? And at that moment, I know the most important thing that matters is read it, for God's sake. Make it your own. I've never read the Constitution until a woman in this room, who shall go unmentioned at the moment, asked me to teach a course in prison. And the course that she asked me to teach was the founding documents of the United States of America, which I had never taught and had no business teaching. So, of course, I did teach the course in prison. Who knows? And so I read it, of course. And I engaged other texts about it. And one thing I can tell you that's fun about this, really wonderful, is that there are a number of very, very well-known American historians who have talked about this moment, and they're quite wonderful. They really are. It's American history at its best. So they're amazing people to read, help you with this. And there's people who've written about it, several that I have loved, who help you with it. So you can work along with it, but it's a wonderful document to just talk with people about, fight about, think about. But you do it whenever the spirit moves you, and so don't leave this room without getting a copy of the Constitution. Don't go to sleep tonight. Read it.
When did you first become, I mean, as a student, was there something that happened in the country that made you think, all right, this is now a document I better understand? I mean, you're an attorney, so in part it was through that possible.
Well, let me put in context my answer. So Susan and I had a conversation maybe a year ago when I was invited here to see this fabulous complex. And we got talking about the importance of civic education in the United States, or the lack thereof. And that's kind of one of the reasons I think a year later I'm here, because here's the pivot right to that theme, Susan. I think the reason that so many of us don't understand the political discourse today and its history is because many of you folks might not have had to go through grade school and high school with any civics education. I've got a few gray hairs, but when I was in high school and grade school in Illinois, it was mandatory courses in civic education. We actually sat around in 8th grade and in high school talking about the Vietnam War, talking about who's on the cabinet, etc. It was mandatory, and I think our country has lost an enormous amount of understanding and history because it is not taught regularly and consistently and importantly in any of our public schools today. Civic education. That's where the problem is. And so those of you in the legislature, those of you who have had influence in the legislature, Vermont likes to be number one in a lot of things. Can we get back to civics education and civics understanding a bit? I'm afraid people have stopped reading history. And you know the great philosopher who said, if you don't know it, you will repeat it. And there are cycles of life that we can learn, and we do, by reading history. So I think that's the real problem. But to go back to your question and emphasize Susan's point, this is a living, dynamic document. It's not static. It's not set in historical stone. And when you have any person who speaks with authority or purports to and makes such a statement, you say, I don't know about that, or that sounds a little odd to me. Go and read it yourself. And I think any person of common understanding of the English language can read the 14th Amendment, Section 1, which says plainly, they are citizens, period. And the only way that you can change this is through a constitutional amendment, and not through executive order, and not through a congressional amendment, because it says it has to enforce and enhance, not denigrate. So let's get back to reading. Let's hope that you all take, I think we have copies tonight.
Yes.
And I'm not suggesting run home and have popcorn and read the document tonight. But from time to time when you read something in the paper and it strikes you as a bit odd, is that really true? Is that nuts? Read it and you'll see exactly what the founders meant. And Liz's point about aspirational, uplifting importance of reading the document.
Questions? Marianne, do you have a question?
I think it's a great question, and I hope that's happening in all of our classrooms today. The debate is important. The questioning, the critique is important. Oliver Wendell Holmes, one of the greatest jurists, once said with regard to the First Amendment, which is on everybody's mind these days, is if you don't like the opinion or the speech, the way to counter that is through better, more persuasive speech. And that's the debate piece. That's the kind of conversation we should be having in this country today about what does the document mean. This is wholly imperfect. We know that. Lots of things were left out of this Constitution. The rights of women, the rights of people of color, the rights of those who are enslaved. None of that is in here. It came later, as we know. So this is not a perfect document. We don't want to romanticize that. But it's what we got. And as Franklin said, it's a republic if we can keep it. It's what we got. So the debate is really important as to how can we improve it? How do we understand it? I hope that's flourishing in all of our campuses today. I wish it were a bigger discussion in society today.
Do you want to question?
The answer is yes. So let me quickly summarize in a sentence or two where we are from a descriptive, not a normative judgment, if I can, and then we can get to your direct question. So I talked about the absolutist interpretation of the First Amendment before. So this court and many of its predecessor courts would say, unless you fall into one of four categories, it is absolutely protected, even if you think it's obnoxious and hurtful and all that. Obscenity, defamation. You can't lie about somebody. That's actionable. Yeah, well, okay, yeah. Any day in the newspaper. Defamation, obscenity. You can't defend a criminal charge by saying, well, I had free speech to go up to the bank teller and say, give me the money, I'm robbing you. Not protected. And the fourth area, which is the biggest loophole and the one that's subject to interpretation and great debate, I hope, is the clear and present danger test. That is if there is a real threat to one's harmfulness, then it's not going to be protected speech. Let me give you an example, which is highly contestable today. The most talked about today example in the clear and present danger test, if something is clear and present and dangerous, then it's not protected by the First Amendment and you can charge somebody criminally for the conduct, okay? So the nuanced analysis is if there is a direct threat test, it's called, subset of clear and present danger. So let me get right to the point. Hate speech versus hate crimes. How can hate speech by the way, I'm being descriptive, not normative. This is exactly what the Supreme Court has said. Hate speech is protected under the First Amendment today. Period. Now, we can argue that, but it is protected. How does it move from being protected to being criminal conduct? The courts has said that if the clear and present danger is a direct threat, so if I point at you and I threaten you, or you feel intimidated, and it's immediate and it's imminent, I'm going to come over there and hit you, that is a crime. It's not protected under speech. Okay? It has to be direct, it has to be focused, it has to be imminent. Right now, you're going to be physically harmed, not psychological or emotional. Argument why we can't bring in emotional and psychological harm. I think that's a fair debate, quite frankly. Court's not there yet. If you can demonstrate that direct, immediate, imminent threat, that's not protected by the First Amendment. It crosses from hate speech into a hate crime. No, clearly not, because the First Amendment says the government shall not censor. This is, again, goes back to my first point. The overarching theme of this Constitution is limited government, the autonomy of the individual against arbitrary, capricious governmental action. That would be censorship by a government agency, your example.
One of the things about this conversation is that the presumption is that we sit around looking, checking on the Constitution to decide about what we're going to do. I don't think that is what happens. I think that there are areas that are intrinsically contentious, intrinsically need always to be examined in the moment, in the situation they're in. Clearly, one of them, it seems to me, is the limits of speech. One deals with whole sets of circumstances that are involved. Obviously, being a responsible person, responsible in the sense of presumably having something to do with policy, and you're on a college campus, is quite different from when you're living home having a drink with your friends at the end of the day. So let's not think of the Constitution as something that controls our lives. And of course, it is one way of thinking about how you make policy and how you decide things. It's not by any means the only way. I just want to make that point, and to make the point that it is intrinsically contentious, this question about what are the most reasonable limits given you're a human being and you have values and you care. It's always a responsibility one has. Should the Nazis be allowed to parade through an area of Illinois which was particularly filled with people who had been Holocaust victims? My own position would be no. It's too much. It's just, I'm about to say something, too much, okay? And that would be my argument, okay? Then let the chips fall where they may. But as a human being, I think one way to misconstrue the Constitution is to say there's certain things I can't even imagine discussing because the Constitution says. It's very clear on this. You're human beings in a world with other people, and you're constantly under the responsibility and given the responsibility of what is the most humane, responsible thing you can do in the circumstances you're in.
I would just comment that if you're a president of a public institution, unlike a private college at Bennington or Middlebury, we are under the constriction of the United States Constitution, and every day I have to follow that because under that language, the government shall not, public institution official, I'm the government, supposedly. So when we have these problems, I am constrained by this document. Whereas, and this is a clear distinction that everybody doesn't know, the First Amendment is against government censorship. If you're a private entity, Facebook, Bennington College, an employer here in Bennington, this does not apply to you as a restraint on your behavior. It does to me, a public official.
A couple more questions, Eric.
The United States Supreme Court, yeah, the question was, is commercial speech covered under the First Amendment? Commercial speech is so-called speech by a business or a corporation, an entity, not a, as I said earlier, not a person. That's the problem, of course, with the Supreme Court's interpretation. The Supreme Court, 25, 30 years ago, ushered in this doctrine of commercial speech, which basically said, and this goes to advertising by businesses, if your advertisement, which is speech, is misleading or fraudulent, you have no First Amendment protection. If your advertising is not misleading and not fraudulent, you have a commercial right to advertise that. Case in point, cigarettes, drugs, certain prescription drugs. So the question is, so how did those corporations get this subcategory called commercial speech? And it goes back to my answer before. I think the court's misinterpreting the whole history of corporate law in this country. A corporation was never intended to be a person like us. It is an artificial construct developed by state government to enable and incent businesses, period. They have a license to do business. They are not a person, in my view. Hence, I don't think the commercial speech doctrine is in the Constitution itself. And same answer to United Citizens. Excellent question. So my example that I was a gentleman over here, if you can show that it is a direct, immediate, imminent threat to you or the small group around you, that would be the clear and present danger, and you could suppress it. But you have to meet that very exacting test: direct, imminent, pointed right at you. If you were blasting out to, "I hate all people X," hate speech protected, because it's not directed, it's not imminent, a physical threat isn't necessarily going to follow. That's how the American interpretation would be.
Yes, and today, and it's physical harm, not necessarily emotional. William, did you want to add something to that? Okay, go ahead. I know.
Yeah, you made several comments about the court's interpretation of what is within what do you do with what the Roberts Court going to do for all of that? No, that was the original.
The question is that
Out of my descriptive into the normative political discourse, and I think what's likely to happen is the Chief Justice Roberts will become what political scientists call the median justice. That is to say, the centrist, like Justice O'Connor was, like Justice Kennedy had been. We don't have one right now. But those who know Justice Roberts well believe that and this is true with most of the chiefs going back, believe that the chief has a special duty to the fidelity and of the court itself. And even though his philosophy is quite conservative, people think he'll actually move more to the center to protect the integrity of the court. And one perfect example is the Obama case, where everyone thought that was going to be reversed, and it was the Chief Justice who, in the middle, said, no, it's lawful, it's constitutional, and quite frankly, he came up with a very novel theory that not many people agreed with. And people believe that he did it for the integrity of the court, because he did not want another Bush versus Gore kind of debacle with the decision. So I think we'll see him move more to the middle, in which case you've got 4, 4, middle. But that will go back and forth depending upon the severity of the public policy and the compelling arguments on either side. Justice Kennedy was never considered a liberal or progressive. We read a lot in the press that's just not accurate. And Justice Kennedy has always been a conservative justice, but he has picked certain areas where he has deep passion, like gay rights case, which is historical and monumental. If you followed his career, it would have been hard-pressed to predict that he might have. But the individual liberty and the privacy and the autonomy has always been strong to him. So you put it in the context of the gay rights case, he's going to write that opinion. But the rest of his career has been quite conservative. It's only in the latter years that he became the median or the middle justice, floating back and forth. But his record is quite conservative.
A couple of just final student questions. Yeah.
Back down to that very factual question. If he's standing up, let's take it out of him. Anybody standing up there with a podium, and they start lecturing and use hate speech language, and they actually turn to a reporter and say, lock her up. That reporter, her report yesterday was lousy. I would say that crosses the line, quite frankly, because that is a direct, imminent threat, and you could have a crowd turn into a mob scene real quickly. Her, right there she is. Go tell her comments were wrong yesterday. See the directness, the immediacy, the imminency, and the context of this could be a mob scene, and it's factually oriented.
Yeah, I think one of the things we need to kind of get into this conversation is the speech of the president is not the same as anybody else. And the responsibilities of the president are not the same as anyone else. So, Lord knows we do not want to hold the president, to extend the president's rights to speak anything he wants by virtue of the First Amendment. Every word from the president has an order of obligation and responsibility that's entirely different. That's just to underscore the extent to which a misuse of the Constitution of the United States is as a daily way to deal with complex issues of great political importance and power. It is not that. It serves an enormously important function in this country, almost one could say a sacred function. But it does not tell us how to live our lives. in all circumstances, and it certainly doesn't tell us about how to use the power we have or to get it, and to use it to maximum effect. And holding the President of the United States to a very high standard of speech is your obligation as citizens. Certainly not to say, well, you know, you can say it. So the only issue, of course, is not whether it goes before the Supreme Court, but what we as citizens do with that.
There are 3 things outside this door that I hope you will all devour: coffee, cookies, and copies of the Constitution. I want to remind those students who are taking this as a class, we'll meet in Design Lab 1 for a few moments, and please join me in thanking our guests for this evening.